Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome into an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder of Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph is a former Army JAG and a worldwide court-martial defense attorney who has tried more than 240 court-martials to verdict and handled over 350 military cases across the United States, Europe, the Pacific, and the Middle East. And in today's episode, we're going to be talking about the part of the trial most people, they never see, and that's the investigation phase, how a defense case is actually built long before anyone ever steps foot in a courtroom. Joseph, it's good to see you as always. I'm thinking of A Few Good Men with Lieutenant Caffey there, where he's like, I never stepped foot in a courtroom, so this is what it kind of looks like. But there's a serious allegation in that movie. So when there's a serious allegation that first lands on your desk, how do you decide where to start?
Hey, Mike, first of all, thanks for having me. How do we start an investigation? Well, it depends on how it comes to me, right? So does the case come to me already charged and it's docketed, or do I get it at its inception? And if I get it at its inception shortly after an investigating agency dips their toes into it and says, hey, we're going to start looking at this thing. First and foremost, I get a narrative from the client. I interview them thoroughly. And then I turn around and I ask them to write a narrative for me. And a lot of times what I find is the written word ferrets out and shows more detail. And so when I'm looking for those details, I turn around and I basically, in law school, they taught us through the Socratic method. So every time, the professor would ask you a question, you would turn around and answer it. And then based off your answer, you get another question from the law professor. Well, that's the way I do my investigations. When I'm talking to my clients, many times the questions that I ask them will turn into new questions based off the answers that they give us. I'm looking for witnesses that need to be talked to. I'm looking for evidence that may corroborate what they're saying. Oftentimes what we find is in this day and age, social media, photographs, text messages are vital. And you'd be surprised the amount of young men and women that wear the uniform that the minute they get in trouble, they decide they want to delete their texts. And I can't stand that when that happens because oftentimes the text messages tell a very interesting story about what happened in the interactions between two people. If, say, we're talking about an assault or a sexual assault or things of that nature. So that's really where we start with the client. What do they have to say? And then think of it as a wagon wheel. The client is the hub of the wheel. And then what they tell you and the various different directions that they can go are kind of the spokes of the wheel. That's the way I kind of describe sexual assault cases to young counsel that work with me from the military. I actually describe it in the inverse. The alleged victim is the hub of the wheel, okay? And then all her stories that she tells are the spokes of the wheel. It's the same thing with the client. And so if we can start to develop the investigation, and then at some point they make a charging decision or they make a decision that they're going to take some sort of action, we then will are authorized to have a copy of the report of investigation, all the statements that come into it, and then we start tearing into that. Because we know, hey, we're getting ready to go to trial. But hopefully leading up to that, we've established at least a good baseline, an idea of what witnesses are supportive to our client, what evidence he has that's supportive to our client, or he or she that's supportive to our client, and just kind of take it from there.
Let's go back to what you said about tearing it up. Or tearing into it, I should say. So the investigation on paper, it looks good, looks official that you've been doing. But when you start actually digging deeper, what are some of the early tells that kind of tell you that something's not adding up here?
So what you want to do first is you start with witness statements. And when you're looking at witness statements, you're looking for several different types of inconsistencies. So I like to look at the alleged victim statement first, her actual statement. And oftentimes it's not written, it's an audio-visual statement. So you have to listen to it. I also like to transcribe them because the way I synthesize information in my head is I like to read it As you can tell, I'm surrounded by books. I read a lot. So the way I process information is I first like to read it if I can. So if it's written work, I like to look at that so I can start to think about it through that lens. But we'll get the audiovisual statement of the alleged victim. We listen to what she has to say. So what we're doing is we're looking for what's called internal inconsistencies, and we're looking for external inconsistencies, and then we're looking for inconsistencies in behavior. So internal inconsistencies are those inconsistencies in which she may say something that just doesn't make sense, um, and it'll be in different parts of the interview. Okay, um, and then external inconsistencies are those inconsistencies wherein she says one thing to one person, or he says one thing to one person, but then says something different to a different person. And then, of course, the inconsistencies in behavior, um, which oftentimes is turned into what government experts like to use as counterintuitive behavior. But really, we have to use our common sense and ways of the world when we're looking at behaviors of alleged victims in particular, whether it's an alleged victim of domestic violence, an alleged victim of assault, an alleged victim of sexual assault, or any other type of crime. What is their behavior after the fact? That is really important because it does tell you kind of the intent and possible motivations behind that. And so we start looking at all of those various different avenues of approach to see where we can pick at the allegation that's being made and see if we can identify a motive or identify an actual lie, something that should have been picked up by the prosecutors but often isn't.
Joseph, I mentioned in the intro about how you've traveled all around the world with these cases, Middle East, etc. So, chasing down these witnesses in unusual places, like take our audience inside. Like, what does like a full throttle investigation actually look like, especially when someone's career is on the line?
You have to be willing to go the extra mile, and sometimes that the client has to have some deep pockets in some cases. There's been several cases where we've had a defense investigator, we've had him travel to, 12, 13, 14 different states and locations to interview witnesses. In some cases, I go with them to do that. Early on in my career, and I still do this from time to time, but I will go hunt down witnesses with my paralegal or with another investigator. Um, and sometimes that requires us to go into a cave in Missouri or go out into a remote beach in Hawaii, like I did last year, where we're taking pictures of the scene. Um, you know, there was an allegation that was made in the case I did last year where the alleged victim said she was drug across the sand. And we looked at the pictures of her and we were like, well, she doesn't have any scrapes or marks on her. That's kind of interesting. I wonder if it was soft sand. So we went out to the beach, and it was on the very north point of Oahu. And that beach is not a soft, white, sandy beach. It is very rocky. And if you were to get drug on it, your skin's going to get cut up. It's going to be, you're going to go to the ER based off the way she described it. We took pictures. We introduced that evidence. I confronted her on it. And of course, my client was acquitted of those particular charges. So you got to be willing to go the extra mile. Sometimes you got to go into places that you're uncomfortable going to. You may have to go to a strip club to find a witness. I've had to do that. You may have to go into dark streets of Bahrain to find a witness because they're so important because of what they saw and what they observed. They can exonerate your witness. So, yeah, you really do have to be willing to go the extra mile for your client because that's their life and their livelihood is on the line.
Let me piggyback off that because how much, especially with your years of experience doing this, like how much of a great defense comes from what you uncover outside of the courtroom versus when you're inside the courtroom?
I would say at least 90%. There are times in the courtroom where you discover something as the trial unfolds that is that changes the specter of things and to your favor, but that rarely happens. As Russell Wilson used to say, the separation's in the preparation, and so the preparation is absolutely vital. You have to really start to think through how you're going to formulate your defense, what that looks like in the courtroom when you execute it. And so the building blocks of that are a thorough investigation, interviewing witnesses, going over documentation, reviewing photographs, text messages, phone records, um, understanding the data, right? There was a case I did in Okinawa 2 years ago where the government thought they had my client in the bag because the alleged victim said, she had texted a friend of hers um, while she was, being sexually assaulted. And so we looked at the DFE data, and it was clear that there was some sort of messaging going on. But really, DFE stands for Digital Forensic Examination Data. And so we looked at that, and we noticed a couple of oddities. And so I talked to my expert, and I noted that, hey, look, we knew all of the data before we walked in. And then when we got there, we listened to the testimony, and then we realized, hey, they're interpreting this data incorrectly because this data is not text messages. These are memes. And we knew what kind of memes she was sending. And that was a death knell to her credibility. So really, knowing really and truly the evidence that you have, understanding what it is, and if you don't, knowing what experts to call to develop that evidence to your client's favor is vital to the defense. And that's all done at the preparation stage. That's all done before you walk into the courtroom. And then, master your case to the point where if there's something that you just can't quite put your finger on, paying attention to what's going on in the courtroom, and oftentimes the light bulb will go on. And that next 10% gets you across the, goal line.
Well, let me ask you about that. So, can you share a case, obviously without giving away the intricate details, but where the official narrative of the case kind of looked terrible at first for your client, and then your own investigation kind of revealed something different? Can you share what you uncovered? How did it change the direction of the case?
Sure. I did a case representing a captain in the Army, and the trial was at Fort Leonard Wood, Missouri. And it looked terrible at the outset because he had confessed to the Illinois State Police for 45 minutes. And it was bad. So when you watch the confession, it was like, well, I guess we need to start talking about a deal. But there was a couple of things about what he had said and his demeanor and affect that made me want to go a little deeper. And so I sat down with a trusted expert, a forensic psychologist, and we watched the interview again. He also wrote an apology note, and the apology note was interesting, and it also caused me to wonder, something about this just doesn't track. And so I started doing some more background on the individual. I'd found out that he'd been married for 10 plus years, got out of his wife left him because about every 12 to 15 months he was deployed. And he was only home on the, home station for 12, up to 12 to 13 months, and then he was gone again. And so that put a tremendous strain on the marriage. She said she had enough. After about 6 rotations of that, she left him. So it caused him to kind of spiral. He made some unfortunate choices in his next life mate. And he decided, when you're with somebody for so long, you have certain behaviors that you engage in, certain things that you say. And when I talked to his previous spouse, I learned some of the things that he used to do, um, when they were intimate with each other. And that was a trigger point for me to understand, okay, now I understand why this statement was made. Um, you know, because the alleged victim had said, well, he said he was going to rape me. Well, that's not what he said. He said, oh, don't make me rape you. And it was kind of a flirty comment, but she turned it around and made it look like he was, basically bullying her in the bedroom. And so what she turned around, because he was somewhat in a compromised mental state, um, how quickly they got into the relationship. It was a 3-month dating. There was a breakup. There was a whole bunch of things that happened in that breakup where unfortunately he was considering ending his own life. And so we knew that there was a tremendous mental strain on this individual such that he could be manipulated into confessing into something that he didn't do. And so we were put in the position to prove that this was a false confession. And that's exactly what we did. And we put him on the stand. and thorough preparation of him going line by line of what he said. He was on the stand for a while on direct examination from me, explaining line for line everything he said in the audio-visual interview that he gave to this Illinois State Police, and then the love note, the apology note, explaining that line by line. And that's not the only time that I've done that. We've had several cases where we've had to really break things down for the jury through, taking the risk of putting our client on the stand to explain it, because now they got to go through the crucible of cross-examination, and that also takes a lot of preparation.
Well, Joseph, as we put a bow on this episode, someone that is listening to this right now, they're under active investigation, let's say, and maybe they're a little overwhelmed and they don't know what the government is doing behind the scenes. What should they understand about how a strong defense gets built during all this?
Get an attorney involved early and fast. I can't tell you how many times, I want to say about 95% of the time, where we get a case at the outset. They have been arrested. They're under investigation. They know they're under investigation. Most of the time, we can get a good result out of that if they call us immediately. Don't delete your data. Don't delete photographs or text messages. Package all that up and safeguard it to be given to your defense counsel, whoever you choose to represent you, because you may not understand what it means. You may think in your head that, oh, there's bad information here. It shows that we're in a relationship and I'm married. Yeah, but it also shows that, oh, by the way, she's got a motive to fabricate because she's also flirting with you too, right? So, and that's just an example, but there are so many things that people do to hamstring themselves, talking to investigators when they don't have to, acting like they don't understand what their rights are, but the investigators do a great job of telling you, this is your right. You have a right to remain silent. Use that. Call an attorney. Say, hey, look, I'm going to remain silent at this point. I'm going to get an attorney, and maybe we'll come back and talk to you later, but I'm not talking to you right now without getting advice from an attorney. People need to do that. I don't know what's going on in our civics courses in high school, but these young service members, for whatever reason, they think it's okay to talk to law enforcement. It isn't. Not without getting advice from counsel, because we're going to ask you a bunch of questions. We're going to dig into what the allegation is. We're going to see what evidence you have. We're going to see what witnesses you have. And that's really, really important, because if we can interview witnesses that saw, heard, or know about the motivation of the alleged victim in a sex assault case, for instance, and we can do it early, we're setting things in stone, and we are setting things up for victory later if the government makes the mistake of taking that individual to trial.
Joseph, thank you for the time, the insights, sharing all your expertise on this. I truly appreciate it.
Yeah, thank you, Mike, for having me. I appreciate that too.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with Attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now. Visit jordanucmjlaw.com. If you're finding this series helpful, do me a favor. Hit like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.